Well, thank you guys for having me. I love the name of the Is There Life After Residency? Yes, there is, and it's going to be great. Aren't you guys excited? So we're going to go over, do I just use the mouse? Yeah. Okay, I'll just click right there. Contracting issues. My dad's a doctor. My brother's a doctor. I work with PLICO and the OSMA a lot. So this is kind of, I do healthcare law. I represent other types of providers as well, but physicians is kind of my niche area, and contracting issues, employment issues, that type of stuff. And it's changed a lot over the, as Sherry kindly pointed out, the almost 3 decades I've been doing this. So we'll just talk about some of the practical issues. We're going to go over, like Sherry said, employment agreements. That is the predominant model these days. 70% of doctors now are in some sort of employment model. Again, that changed. My dad was in private practice in a small town. So that is, over this span, has changed a lot. Doctors used to be all pretty much small business owners, and now you're in an employment model. But there's still some medical practices that operate independently in various models. And so we'll talk about, buy-in issues, if that's something you're interested in, physician-hospital integration, and then just briefly mention kind of a new trend is these big private equity firms buying medical practices and things like that, and just to be aware of it. So on employment agreement, just some top things, and not necessarily, this one I put kind of common mistakes, and we're kind of back into some of these issues, and it's not an advertisement. You really, whether or not you consult an attorney, but the reason I put this one up front is because if you're going into something, usually in today's world, if the hospital, if you're going to go into an employment, all of a sudden that got weird. An employment agreement with a hospital, St. Francis, Integris in Oklahoma City, they have their contract templates. And they're not going to say, oh yes, for you, we will do a whole new contract. It doesn't work like that, unfortunately, these days. They've got, their attorneys, their teams of attorneys have written, this is their model. And so, but that doesn't mean there's not things in it that you can negotiate. They're just not going to scrap the 20-page document and start over, is what I'm trying to say. But there's terms within it. And most importantly, is getting someone so that you understand it. I can't tell you how many people just, this is a template. They're not going to change it, so I'm just going to sign it without understanding it. And usually, okay, things rock along. It doesn't become a problem till it becomes a problem. And so it's important going into something that you understand the terms of it. Just expectations are huge. And you just want to know what, especially the compensation formulas, which are complicated these days. That's important. You want to know how you're going to be compensated, what the criteria are, that kind of thing. So oftentimes, though, if you wait until the very end to have it reviewed or for yourself to sit down and take the time to review it, you've gone kind of to an awkward place in the communications to where you're having to back up with them and say, and they're going to say, we thought we had an agreement. You already signed the letter of intent. We're going along this. So if you're going to, make sure you start in enough, at a process where you can make some changes if you want to. Also, it's important for another reason that a lot of times you go to your recruiting dinners, you do all this stuff, and maybe there's things that you've talked to the employer about verbally, but it's unique to you. That is a unique thing, and it's not in their template. I don't know, some examples, maybe if you have large systems have multiple sites, and you really preferred and you've been recruited to one site, but I guarantee you there's usually language in their contract that says, at our discretion, we can move you wherever we want within our system. If it's with a large system, and you say, but I have kids and I want to be within 15 miles of their school in case there's an emergency, or you have your reasons, then you may need to put that in the contract. Or if they won't, like I said, a lot of times they won't change their template, but they will sign a letter agreement or a side agreement or addendum for that specific. So again, you don't want to have verbal agreements that do not get reflected in writing. If it was important enough for you to bring it up, if you said, hey, I was trained on this new piece of equipment that's new. You guys are young doctors coming out of medical school. Your facility doesn't have it, and that was a verbal agreement that you said, yeah, we'll buy you the equipment, then you need probably to have that in writing. And those are the type of things that unfortunately then come back after the fact for young doctors. Well, I was recruited here and they said that they would remodel and I'd have this extender, a mid-level hired, and none of that's happened. Well, let me see your contract. And they give me the contract and it's never in there. So those are the reasons, if you think you're in some of those situations, that you might want to consult with someone or make sure you've read it early on in the process. Another thing that I always put when I review physician contracts is I have this, kind of standard stuff that I go over with doctors. And I say, first of all, have you done your due diligence? I know you're excited. You want to get your first, full-time job. You've been working your tails off. I understand that through your residency, but the post-residency job. And so have you visited? Have you asked good questions? Because no matter what is in writing, if it's a bad culture, if administration has changed and they're not physician friendly, if a lot of people have left recently, no matter what in writing, you can't make up for a toxic work environment. So have you visited? Do you know your colleagues? Do you know their history? Have a lot of people left lately? Just understand, a lawyer can't, we can help you with the written terms, but that doesn't mean you're going to be happy in that job if you haven't done your own due diligence. And that comes up a lot too when we get to private practice. Then you really need to, because those that have been able to stay independent of hospitals and and stuff like that, usually these days have pretty complicated business models. And so you want to know going into one of those, large physician groups, or what are you structured? You're hiring me as an employee, but do you have other entities? And we'll talk about that more in a minute too, but you just make sure you've done some due diligence. And that's why sometimes an attorney can help you formulate those questions, because you've been doing medical school classes, not business classes a lot of this time. So you may not even know really the questions to ask. Is this your only entity? Do your owners own other entities where they make more money through those entities than the practice entity? And are you pulling money? So somebody like, an attorney who's done a lot of physician deals will actually help you, or could help you, formulate your questions that you don't even think of to ask. Okay, employment agreements, then you actually get a written document. Sometimes people will say early in the process, will you sign this letter of intent? Those are usually non-binding. Just make sure it has non-binding language in it. And then you may get that, and then to an employment agreement. Or some hospitals or employers will just bypass a letter of intent phase. It depends on how early in the process you've started, and they'll just present you with a draft employment agreement. Like I said, the most important thing is that you understand it. That's what mostly I do these days with physicians in employment agreement reviews. Again, there may be some flexibility where I suggest, hey, I've looked at a lot of these lately and the signing bonus is either not there or is low. So I can help you hopefully, or any attorney can help you hopefully identify some things that, I've checked the MGMA data and this salary seems a little low. Those are the type of things that you can change. But it's also important to just understand some of these terms. Usually there's a lot of defined terms. You have to understand too that the systems, the employers, they draft them kind of one-sided. I mean, there's no nefarious intent about it really, but they want you to represent, and here's what you're going to do. And then when you get to, well, what's the hospital or what the employer is going to do for me? And it'll say, we pay you. And that's it. So you want to understand both sides of that, what you're representing to. Usually the agreements contain things that you represent and warrant a whole host of things. I haven't had any licensure issues. I finished my residency, blah, 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 and it'll go down that. If there are any things in those that you can't, like if you've had some issue in the past, it's always better to disclose it up front. It's usually not a deal breaker, but I am telling you, even though it's hard, even though if you have anything in, that you can't satisfy those, it becomes a condition that they view as an honesty issue, even though you're like, I wasn't dishonest about it. I just didn't want to talk about it. You know, whatever that is. If it was a conviction, a DUI, whatever, it's better to disclose it up front, because if they do their criminal background checks or their data bank reporting and they find anything, then it actually ends up being more problematic than if you just disclosed it on the front end. So be aware of that. Also, within employment agreements, again, they would be 100 pages if they incorporated everything that all of the terms in the agreement. So you will see things in employment agreements where we do in the legal world incorporate documents by reference. And it'll say, you agree to comply with our policies and procedures. But I mean, you're like, what policies and procedures? You may need to ask. I mean, if they have, they usually incorporate by reference compliance policies. If you're going into a Catholic system, understand they always have that you will comply with our, they call it something, I'm just blanking, they're Catholic directives, because Catholic systems have unique things, services they will not provide and things like that. So you need to know, okay, I'm aware of that and I can comply with that. I agree to that. So if there's any things like that are incorporated by reference, you may want to say, can I have a copy? Just so I can look them over. Because usually, again, compliance and agreeing to comply with those policies and procedures, if you don't, they can be grounds for termination at some point. So you want to know, and usually it's stuff you're going to comply with it. I mean, you will be, but it's just good to be aware of it. And like I said, I already mentioned what's not there. Those are most often, those are verbal type agreements that you made about specific things. And again, it's not going to be in the template that they just routinely use. So make sure you understand that. Failing to understand the compensation formulas, they get very complicated these days. And usually, if you're going into most Oklahoma hospitals right now, you hear a lot about moving to value-based and all this stuff. Still, the predominant model in Oklahoma is a work RVU formula, where going into it as a young physician, you may be guaranteed a certain amount of income for the first year or two, because they realize a hospital, you're working, but there is a lag in making money for your employer because of the billing cycle. So you may be working there 3 to 6 months before they get any money from your services because of the time it takes to submit claims and get paid and that type of stuff. So initially they are subsidizing you most of the time, and you have to realize that. So a lot of times you will be guaranteed a certain amount of compensation initially in the contract until you're up and running. And then they switch to a work RVU formula, which is based on your production. Or they may start that up front. It's important you know what kind of compensation model. A work RVU formula, again, is a production-based. You're probably aware of how you bill, and they assign these work RVUs to you, and then they multiply that by a conversion factor, and that's kind of your compensation. But these days, there's that. And then there's usually some maybe incentive compensation on top of that. Will you meet certain quality metrics, patient satisfaction? If you are just killing it, above a certain amount, maybe you get additional, or that work RVU conversion factor goes up. Usually I recommend to young physicians, have they presented you with a pro forma? I mean, it's good to see all that written out, but for me, it's easier. Okay, can you give me a spreadsheet that shows if I generate this, I get this amount of RVU conversion factors, my income will be this. If I do this, see it and write. Make sure you understand how you're getting paid. On a work RVU formula, it's also important to understand, do I get this amount of work RVU when I perform the service, when I record it in the electronic medical record and I've done it, or when the claim is dropped, or when you get paid, when you get the reimbursement? That makes a huge difference. What is the timing of when you're going to see that compensation? So understand that. Also understand, of course, things that may negatively affect your compensation. And for well, you can have maternity or paternity leave these days. Now, so if you're going to have a family, if you're on a production-based model and you're not working, your production goes down. And so that actually comes as a shock to some folks when, they have take off a certain year and they thought, well, I've been making this. Well, if it's a work RVU formula and you're not there to generate the work RVUs, you will take a hit. So you either need to negotiate that in advance and say, I will get a minimum, spread out over this time, or you have to save accordingly because you will take a dip in the year that you have a family. So understand or start your family. Benefits, very important part of any physician compensation, any employee. Understand what benefits. And again, this is an item that usually is incorporated by reference because employers want to reserve the right to change the benefit package, and that's common. But if you need to understand, okay, well, do I get dependent care on my health insurance? Huge amount. Do I have to pay any for my spouse or dependents? What type of disability? It is very important for physicians usually to have, in my opinion, this is, I guess, my opinion, but adequate disability insurance. Because sometimes the package that's provided for the employer will be kind of a standard disability package, and it may be adequate to replace the income of a lab tech or, at the income level somebody else, but it may not be sufficient to replace a surgeon's income or a high-performing surgeon. And if you've got expenses and you're out there and you're used to working or having a high income and you, heaven forbid, are injured or disabled for a time period and you need to replace your income with your disability insurance, you need it to be adequate or as close thereto or have savings to replace your income. And so be aware of that. Things happen. We've had, doctors out with long-term COVID. You can get, the most common, ironically, that I keep seeing are doctors that go skiing and hurt their hands. Well, a surgeon can't operate with a thumb that's been back by a ski pole. I mean, weird things. So you want to make sure you have adequate disability and stuff like that. Also, you may need to think about earlier in your career, if you haven't already, getting with a financial planner to help you because hopefully, you're all going to make good incomes and that type of stuff, tax planning, estate planning for your dependents, how you're going to invest the money and save and all that kind of stuff. So think about those things in advance as you go through there. But disability, your 401k, savings, again, is the hospital or your employer, is their retirement plan what you expected, or do you need to supplement it in some way? Like, do they match it all? How much in their 401k or whatever will they match? And is their plan going to get you to where you want to be at your retirement? I know you're young. I mean, thinking about these things in advance, you're like, probably, I don't need to worry about that now. But I'm just telling you, the sooner the better, usually on those type of things. I already kind of mentioned this, just, not understanding the terms, not recognizing that the agreements, may not always be, they're going to be most beneficial to the employer. And I mean, that's just how you negotiate and that's how things work. And sometimes physicians just expect, why wouldn't they just give me the best offer they could? Well, that just doesn't work like that. So just recognize that. And especially these things, and this is again where somebody outside, attorney or somewhere that's really business savvy could help you, is looking through. And when you're going into one of these contracts, it's hard to understand that you read and review the contract to determine what's going to happen when the contract ends. Because no one thinks, that it's going to end. Maybe you think it's just going to keep going, but understanding, okay, when I go into this, I need to understand what happens when this contract ends so you can protect yourself from negative things. One thing, example, tail insurance on your liability insurance. One of the benefits you need to verify, obviously I think 100% of employers, if you're in an employment model, they're going to provide your liability insurance. And you do that. Question though comes up, what type of policy are they providing you? And what happens when the contract ends? They tie together. There's two types of liability insurance policies. One is called claims made, one is called occurrence. Back in the day, again, this is one of those things that has changed over time. Here in Oklahoma for decades, and it's considered the gold standard of liability insurance, would be occurrence. And so the key to that is that you're covered from, you start your job, you have an occurrence-based policy. What that means is it will cover anything that occurs during the term that policy is in effect. The reason that is important is you may already know that you can be sued for medical liability negligence for years after the event occurred because of the statute of limitation. If you're in pediatrics or treat minors, it can be as long as 18 to 21 years, the time period during which you could be sued for an adverse event. So so the best type of policy, the gold standard, is one that covered you for anything that occurred while the policy was in effect. You don't need what's called a tail insurance policy if you had that kind of policy, because if you had the insurance when it occurred, it would cover you. The problem with that is a lot of those policies don't exist anymore because it became actuarially hard to predict, and for insurance companies to predict how much reserves they would need because of the long statute of limitations. And so most often, or oftentimes now, what you will have instead is what's called a claims made policy. That means that you have the policy, but you have to file the claim during the time the insurance is in effect. The problem with that is if you leave employment, you change insurance companies, that policy is not in effect anymore, and you could be sued off into the future and you don't have coverage anymore. So that what addresses that issue is an extended reporting or tail policy, is what it's most commonly called just in the vernacular. You need a tail policy. Okay, so here's the situation. You need to review the contract to say, usually the contracts will say, we will provide you employment, or we will provide your liability insurance while you're an employee. If you change, you have to buy the tail. The tail policy can be 1.5 times 1 year's premium, which is usually not an insubstantial amount. So you need to know, I think you need to know going in, so that if things, you just need to be aware, hey, if I ever want to decide if things aren't going well, if I decide maybe I have a better opportunity over here, one of the factors that you need to take into account is if I leave, do I have to buy my own tail? And you have to be prepared for that, because it could be $30,000, $40,000, $50,000 that you owe your back employer. It's also a point that can often be negotiated, though. And what usually I see is, okay, either they pay the tail, or at least as time goes on. If you've worked for them for 5 years, they have been able to probably make money from your services. You've been, a good employee. They should pay your tail after a certain period of time. Or it's something you need to negotiate with the employer going to. Is like, look, I'd love to join you, but I'm going to have this financial hit over on here because I have to buy my tail. Would you help offset that? So just those are the type of things going in so that you can better protect yourself later. The area that you usually can negotiate are just some of those extra things. Does your contract include a signing bonus? You're kind of already past this point, but sometimes, especially if you're going to rural areas, it's not uncommon for some hospitals to pay stipends even during your fellowship and residency to help support you. Or your student loans, do they include help with repaying any student loans? You can get terms like that oftentimes. Be aware, though, that sometimes when you get benefits like that, they will tie it to kind of like how long you work for them. They'll say, we will pay you a signing bonus of $50,000, but if you leave within 5 years, you have to pay a pro rata portion back. Like every year they will forgive $10,000 and you work it off. So you got to understand, again, that would be something, okay, in advance, if I get in this and I have one of those provisions in my contract and I decide to leave after 3, I may owe them money back. So you got to know, going into those type of things. Another thing that's often in employment agreements are restrictive covenants. What does that mean to you? Know that in Oklahoma, this is a Oklahoma specific thing. So if you leave Oklahoma and go to another state, you need to check what that state does in this. Covenants not to compete in employment agreements, pure employment agreements, are not enforceable under Oklahoma law. They may be in your contract. A lot of employers especially will put them in there for, thinking that, hey, they won't know that they're not enforceable, and they'll adhere to them out of more fear and things like that, and they won't compete. They are not enforceable under current Oklahoma law. There's also a national federal trend to do away with covenants not to compete. We'll have to see how that, but in Oklahoma, as long as I've been practicing, they're not enforceable. They're considered a restraint of trade, and you can't enforce them. But what is enforceable are other types of restrictive covenants, like a non-solicitation clause is enforceable. A non-solicitation clause means it usually says in there that if you change employment, if you leave our employment, you will not take with you our patients. And this is sometimes hard for doctors to understand because you view the patients as your patients. They come to you. Your employer says they're our patients. And so they say you cannot, solicit our patients to go with you or our employees. Those are enforceable, usually. And what that can trip you up is, well, what's a solicitation? If you have a good, relationship with your patients and they Google it, which is so easy today, and they find where you go and they follow you, you didn't solicit them. Solicitation is an overt act like, I know I'm leaving, I've given my 30 days notice or whatever, and I'm giving you my new business cards in the waiting room on your last visit, or I contact you, or I try to copy, get on the computer and copy down some addresses. That type of stuff is what they consider solicitation. Any questions about employment agreements? Yes, sir. Yeah. What I recommend is if you know you're leaving and you've given your notice, to coordinate with your employer on what they expect, just to eliminate, problems. Because in today's world, especially, I know in Oklahoma City, they would say that we're going to have a problem with that. They would tell you, in some cases that I've been privy to, they will say, we don't want you to tell them anything. Because they are our patients, and we will contact them and we will reassign them to one of our other physicians. So literally, that is very hard for physicians to think, because they're like, I have a relationship with this person, and the next time they come, I'm just not going to be here. They're going to see somebody else. They would not want you to even tell them they're leaving. Yeah. Yeah. So coordinate that is the easiest way, and communicate with that with the employer on, can I at least tell them I'm leaving, and just communicate often is the best. I've had some in the Norman, Oklahoma City area that would call the doctor's next employer and tell on him and say, if you're switching, this is just an example, from Norman Regional to Integris, one of those, the counsel for one would call the counsel for the other. This is just, and say, we'll file an injunction against you, the next employer. So it causes problems for your next employer too, because that's usually how they handle it. So just communicate through that. Somebody else, I saw, yes, sir.
I'm curious, if you tell them, hey, I'm no longer working at this place as of October 31st, well, where are you going to be? Can you get away with,
That's, yeah. I mean, I would do that before I'd give them a specific address. But literally, I've had some that they don't want you to even say anything. Yeah, I mean, and yeah, it gets pretty ugly at some points. And so just be aware of that issue. Some people are more gracious. Some people will work with them on a letter to patients, and we'll collectively work on it. But especially if it's a really competitive type practice and they want to retain all those patients, you will see, unfortunately, an ugly side of healthcare sometimes in those situations. Because if it's really competitive and they want to keep the patients in their clinic, they won't want you to say anything. Yes. Huh? I mean, it's hard. I mean, an injunction, they'll file a lot of times. Yeah, practically, I mean, are they going to go file and tell you not to do what you do? Like I said, they usually figure out other things to do. They'll call the place they know you're going and cause problems that way. Or they'll, sometimes you have language in there with a financial penalty that you will, that if you do, they'll just withhold money that under the terms of the contract. So you have to just read the contract and see what they've said. I very rarely do see them actually go get an injunction because that is in effect. I mean, it'll say in the contract they can. And certainly if you're really doing something overt like sending out letters using their mailing list, they can enjoin that. That's usually not what happens, though. It's more of these things. So it becomes a practical issue more than a real legal issue. But it's unpleasant. It's unpleasant for the doctors that are, trying to do the, I like the patients. They like me. You feel that's just one of the unfortunate, that's where medicine and business don't mix sometimes very well. Okay, practice buy-ins. I said I'd go over this a little too. If you're in a situation, this is, like I said, it used to be every physician. You did not have an option of employment, 20, 30 years ago. You would become a small business owner. You would go get your loans and you'd start a business and you'd buy equipment and that kind of thing. That really isn't the model now. But there are some large physician groups that are independent still, quasi-independent, or there's some still smaller practices or maybe some sort of specialties that do more like plastic surgery, cosmetic surgery, those type of things that's more not payer, so tied to payers, and you don't have to have the sophisticated IT and billing systems. And so there's practices like that if that's your area, this will still apply to you all. And those type of arrangements are varied. And this is where I said this is definitely one area where you may want to really check with an attorney, because the models and the organizational structures of these type of arrangements are getting very complicated and they're varied. It's not as cookie cutter as going just, into an employment model. So understand, and if you are, a lot of times these days, young physicians coming out into a private practice situation, they will employ you going into the arrangement with some thought that after you've worked with us, then you get to buy in to the practice. So but it's amazing how many times that is definitely a situation where I get things kind of too late in the process. Like, I've been an employee here for 2 years and they told me after 2 years I'd get to buy in, and I'll say, well, okay, send me the employment agreement, and the employment agreement won't say anything about the buy-in. So then you have a verbal agreement that in 2 years you'd be allowed to buy in. So the number one thing is, if you're going into that type of situation where you have an expectation that in a certain period of time or at a certain level of productivity or whatever, you will be granted the option or the right to buy into an entity, get that in writing, or at least get some notion. Now, they may, what is you say in 2 years I get to buy in. Does that depend on what if I do have an accident and I'm not as productive? Will that get delayed? Is it based on the revenue I've generated? Is it based on the work RVUs I've generated? Is it just a 2 year, in 2 years I'll be buy in? If it's a large practice, does it have to be a unanimous vote of all the partners, or does it a majority? No, going in, so you don't have negative, unexpected negative surprises where all of a sudden, what if you don't vote me in? Does that mean I'm terminated, or do I just continue under the employment agreement for another year? Know those things going in. Even if it's not binding and you can't get them pinned down on those type of things, at least get some generalities in writing. Also, this is where, especially you may need to get tax advice on this, because there's different, and we could do a whole thing on corporate law, but just understand there's different types of entities. So that would be important from your tax perspective. Is it just a normal corporation, the entity, or is it an LLC? LLCs have what they call pass-through tax treatment. So all of the money comes out. You don't get separately taxed at the corporate level. It just comes out. Some of these arrangements want you to form a PLLC, a professional limited liability company first, and then your PLLC is the owner of the practice, not you personally, not Jane Smith. You need to know that. You need to form your PLLC. Just by way, this is an aside, but it gets Oklahoma, we don't do things normally a lot of times. You will ask, do I need to form a professional corporation or a professional limited liability company? In Oklahoma, the laws state, for whatever reason, licensed professionals can form a PLLC. And then that means that nobody else that's not licensed can own part of that professional entity. A professional entity can only be owned by licensed professionals. And even certain, like an attorney and a doctor can't form a PLC together. It has to be all doctors in one and all that. So licensed, but you don't have to. And that's what's weird. People don't understand that you can just form an LLC too. You don't have to be set up in a professional limited liability company. But if you want to be exclusive, meaning we don't want anyone that's not a professionally licensed ever to have part of our entity, you form a professional entity to keep others out. It's very weird. So that's that. Also, if you go to other states, some states have very restrictive notions of, they call it the corporate practice of medicine. And doctors, licensed doctors, cannot be employed or in an entity with non-licensed. Oklahoma does not enforce that either. We don't have that concept. So those issues may come up if you cross lines. And this is where I come into some of these models to stay independent these days because of reimbursement, regulation, all of the things that make medicine so dang complicated these days. Your more successful private practices are usually now diversified in some way. And so this again is where you would have to do your due diligence is, okay, you're recruiting me to come be employed by orthopedic specialist of Utopia, whatever, that entity. And I am employed by orthopedic specialist Utopia. But what you don't understand maybe coming in is where they make their real money is that those owners of this practice also own an ambulatory surgery center, or they own over here too. So you would want to know coming in, when do I get to buy into those things? Because the practice, if you're in an LLC, remember, you're going to put you on a production formula. You're going to eat what you kill. That's what we say in the legal world. You produce. So there's not going to be a lot of money left over in that entity. Usually at the end, they distribute it all out under your production formulas. So it's not like you may make some extra money at the top from the next recruited doctor. But other than that, sometimes the money is in other entities. So know that you have to check all that out, ask those questions up front. Liabilities going into these situations, again, due diligence. Have you been subject to payer audits? How profitable is this business? Can you show me some financials? Do I know what I'm going into? Or especially the young people. If it's a lot of older doctors, I'm telling you, you do not want to be funding somebody else's retirement. If it was my sons, I have 3 sons, that's what I'd tell them. I mean, if I'm the older and I'm in the place where I'm like, I would like, and a lot of these practices, because if they've really been in existence a long time and they haven't updated their models and their corporate documents, in the old days, that was fine. That you would be basically the young people coming in would then buy out the older doctors, and it would be expensive though. that your buy-in amount, and that's what you need to also ask up front. Okay, is what I get to buy in 2 years. What does that mean? Does that mean I've been working for you for 2 years, so you just give me shares in 2 years? Or are you, I mean, a very rude surprise is if the young doctors don't understand you can buy in, but it's going to be $500,000 or more. And you're like, wait a minute, I didn't understand that coming in. So you need to know, what is the buy-in I'm going to be expected to come up with in 2 years? And is it I'm buying out the oldest doctor and I'm giving them their retirement? Well, in that model, you don't want to be the last doctor there because there's going to be nobody to buy you out. So you got to understand the dynamics of that going in. Have you had compliance issues? Does this entity I'm buying into have debt? Because these days, every bank, if they loan money to a physician practice, they require every doctor in that group to sign a personal guarantee. So you need to know going in, well, you bought this fancy MRI, and I'm going to be on the hook. Part of the documents they're going to hand you is, here's your subscription agreement. Here's your, you're going to own these shares. Oh, and the bank wants you to sign off that you're personally liable on this $2 million debt. You need to understand those things going in. Have there been lawsuits? Is it as make sure, is it as profitable as they've told you it is, and things like that. Just understand the documents you'll be given, a subscription agreement to get your units or your shares, depending on what type of entity is, and then are you going to be given a purchase agreement? Are you going to have to buy in, literally buy in? Understand, again, just for your education, so you don't get mixed up, corporations, if it is a corporation, the correct legal terms, or you get shares or stocks. In a limited liability company, you'll get membership interest or units. A lot of people in the medical profession use those. They'll refer to it as stock when it's really a limited liability company. That's why you need to do the research, because lawyers know this, and it's very important to us to use the right nomenclature, but others, we don't expect others to. You just need to understand what you're getting to. What type of governance, if you're buying in, ask for copies of it. Where is your stockholder agreement? Where are your bylaws, your employment agreement, your deferred compensation agreement? Like I said, it gets very complicated. Some individual private practices have very complicated document structure. And so you need to be aware of all of those. A stockholder agreement, you may buy in, but they may have side agreements on right of first refusal. You can't just freely sell your stock in this entity to anybody. It has to be either first to other members of the group, and then it has to be pursuant to this formula. So that is why these things get very complicated. An agreement, the governing documents of a limited liability company or a PLLC will be referred to as the operating agreement as opposed to the bylaws. So get those documents as well. Major issues in any type of buy-in, the buy-in terms. And by the way, I probably should have said that, these concepts really apply to any type of entity. We're talking about your practice buy-ins, but doctors can be very entrepreneurial these days. So this would be if you're just investing in anything, a restaurant chain or some totally unrelated business. These things still apply to those. What are the buy-in terms? If you're buying in, who makes the decisions? That can vary wildly too. I'm going to buy in at a third, but do I have votes as a third? Or some, in this world we live in now, sometimes you'll have non-doctors, business people setting up deals and offering them to you all, and they retain the control. So you may be paying 25%, but you may have zero voting rights. And you need to understand that going in, that you're a passive investor. So you need to trust the people you're investing with in those situations a whole lot. Transferability of ownership. A lot of times doctors, again, when you get things pretty complicated, you'll do some estate planning, you'll do some financial planning. You may want to set up some trust eventually for your family. And you can have, a lot of times the documents will allow you to transfer the ownership to a trust of certain entities, some will not. So you need to understand that. Compensation allocation of expenses. Of course, you need to know, how am I going to get paid? How is money distributed? How much expenses does this have? Again, some of these setups, I mean, if I showed you an org chart, you'd be like, holy moly, because they will have, here's our practice entity, but we have a management company that really manages it, and we have an employee leasing arrangement that provides the employees. Well, guess what? Those are expenses that come off the top. We pay our management company first, those are all things, and then it's only what's left that gets divided out to the doctors in this arrangement. And that's why you go back, remember I said, understand how many other entities they own, because you could be excluded as the new physician coming in from the opportunity to own the management company. You just own the physician practice, but they pay the management company that maybe some of the senior doctors own first. So again, understand those type of things and how complicated it can be. The expenses, there are doctors that love the fancy offices with the fish tanks in the waiting room and the 76 flat screens. Then there are the other end of the spectrum that the doctors, have, I don't know, it looks like Goodwill chairs in the waiting. I mean, you have that spectrum. And so okay, well, that's not important to me. I don't have that kind of practice. I'm not going to be doing this, but I don't want to pay for the flat screen. I don't want to pay for and so I don't want those kind of expenses. You have different mid-level expectations. You have practices that are set up to maximize mid-levels, kind of in a pyramid, and they're very high expense practices. And that may be how you want to do it. There are those that are on that lower end that we just bada bing, bada boom, we're getting people in and out and very low maintenance. So understand the expenses and I've had doctors that they hire a barista to come in every morning and fix coffee for their whole staff. And then when they want to go negotiate with the hospital to buy their practice, and they're like, we're not paying for the barista, that kind of stuff. So just understand that. Restrictive covenants again, note this, listen to this very carefully. If you own, I said in the first, covenants not to compete in a pure employment agreement are not enforceable. They are enforceable if you're an owner. So once you become an owner and if you sell back your shares, you sell back your units to go compete in somewhere else, they can enforce the covenant against you. So understand there's a distinction. Once you're selling goodwill, the covenant not to compete does become enforceable. And then, of course, major tax issues depending on the structure, depending on your situation. And the next couple of slides, Sherry, I'm probably running out of time, aren't I? Oh, I'm talking so fast. Well, another way to look at this is on the next couple of slides. And this is the way lawyers think, which is sad probably, but that's like I've been telling you, we go into the thinking about how to protect you when things go wrong. And that's why we look at these going forward and you're like, you're negative. Well, sometimes things go wrong. And so go through when you're looking at these arrangements about here are some of the sources of conflict that often arise in practices. And so you need to kind of solve for that in the documentation before you go in. And it's always the number one, compensation expense allocation. If you're in a group practice, it's really hard if you're so far apart on your expectations about expenses, like I just gave you those. If you're, in a 2-person practice with somebody that wants to hire the barista and you're like, no, I want to take that home in my compensation instead. Everybody can go to Starbucks on their way here. You've got to solve for that in your agreements. Departing physician, how many times I said this up front, you want to know some of these agreements were drafted in private practices that still exist, are still operating under documents that were drafted when the first founding partners started it in the 70s. They should have been updated. They don't fit today's times. And so some of that, again, is a bad thing for young physicians like you because you come into the practice, you're gung-ho. I'm going to inherit this. Dr. Smith said he's going to retire in 2 years. I'm going to get his whole base. But you didn't look at the agreement, and it says when Dr. Smith retires, he gets a buyout of a big chunk of change. And that's when the young person is then funding that person's retirement. And you do not want that. So before you go in, you need to say, Let's change that. I'm glad to join you, Dr. Smith, but I do not want to fund your retirement at the back end in today's market. It just doesn't work. Understand the tail coverage again, your non-compete. Also understand if you join a practice in an employer these days, again, a lot of physicians don't understand that the patients are the employers or the practice, and so are the medical records. So again, they're like, well, I'm going to go set up my own private practice. Can't I just copy? I expect all my patients to follow me because you couldn't possibly take the whole volume of this. No, they can make you pay for them. They can say, well, we'll let you pay for them at your expense, especially in today's electronic medical record world. How do you get those migrated over? There's usually a cost to that. So think about those type of things up front too. You can't just take, like in the old days, you can't just say this file cabinet's mine and we'll move the whole file cabinet. So you have to make arrangements for that. The buyout calculations, on-call responsibilities. I should have brought this up on the employment agreement too, because this is in both. Understand what those are, especially your situation. If you're in a specialty that is hard to come by and you want to define what are my on-call responsibilities. That may address in those policies and procedures that are incorporated by reference. You cannot be on call 7 days a week. and you want to make sure that you're not worked to death. So, is my call 2 days a week? Is it 1 day? Do I share it equally? Does the group share call equally? Or have you tried to make the senior physicians exempt? And am I going to end up with this huge burden? So understand your on-call responsibilities. Also understand they may change. If you go to an employer and you go there and there's 4 doctors and you think, okay, well, at worst, it's every 4th day. What if one of those leaves? What if 2 of those leaves? So again, it's important to maybe say, don't just say, oh, I share with 4 doctors, because that can change. You say, hospital, I will never do more than 2 days a week in your contract. Otherwise, they can creep up on you and you say, well, you said you'd share call and we only have 2 now. So guess what? You're on every other night. I mean, make sure you understand that going in. Support staff, do you have control over hiring, firing, at least selecting your own mid-levels that you work with? That type of stuff. Outside income and activities. Again, look for that. If you are really entrepreneurial and you want to, at your young and energetic age, moonlight somewhere or develop the next great medical device or whatever it is, those issues should be addressed too in your contract. If you're in an employment contract, it will say something like, whatever you develop while you're our employee is ours. So, and if you're, develop the next great implant, then you may have issues there. So you need to carve out your outside activities, but also know if you're employed and you moonlight or you do some things that are outside your contract, even if it's permitted, your liability insurance won't cover you. You'll have to have a separate policy. Most often, your employer's policy won't cover it. So understand that as well. Again, going back to the buy-in terms, am I going to buy in at no buy-in? Is it sweat equity, a flat formula? Are we going to have to go out and get a fair market valuation, which also costs money? Understand those going in. Control, who controls this practice? Am I coming in as an A stockholder with full control, or am I coming in as a B or C with no control? Do you have protections as a minority owner? Again, some of these practices, now that we have private equity entering the market, can be very valuable. And if you're coming in and your agreement says you have no voting initially or you don't vote, maybe say, well, I've got to have protection. At least if we get $1 billion offer from some private equity firm, I have some share in it or something like that. So be aware of that. Sale assignment, right of your first refusal. What are triggering events for repurchase where you can be bought out basically without your consent? Understand those things. Valuation, again, sometimes there are compliance regulatory issues that you may be aware of. Have you heard of the Stark Law, the anti-kickback statute, those type of things? I'm seeing some. Medicine is very, very regulated these days. And so also understand that the hospitals, the employers they're subject to laws that prohibit them from paying you for your volume or value of referrals, and it cannot be not commercially reasonable. So understand that hospitals, your employers, they want you, they need you, but there are limits on, you can't go to them and say, I'm a first year doctor and I want $1 million a year. I mean, they have limits, regulatory limits on what they can pay you. So sometimes they have to say, well, we got to go get an independent valuation to tell us that this is fair market value compensation. Understand those issues come up sometimes as well. The transferability, if you're buying into an entity, a practice, or any type of entity, and you want to buy out or you want to leave, understand how you're going to get paid. Does the agreement say they have to pay you in a lump sum? Does it say they have a payment schedule? Have they purchased insurance on your life to pay for things? I mean, would your estate, if you died or during your ownership, would your estate get a payout? Understand all those things as well. Compensation and income distribution in any group is key, very key, because, again, nothing causes conflicts within a group practice or anything if you feel like you're getting the short end of the stick, that you are. So I very rarely see these days where compensation is in any group practice is based equally, because it's never equal. Somebody's going to have a good month, somebody's going to have a bad month, somebody's going to have a baby, or somebody's going to have an operation. And in most medical groups, you need to take care of yourself and have some savings and things like that, because it's very hard and causes a lot of conflict in groups if they're like, okay, our documents say that they still get the same draw, but they have not worked because they chose to go to Vail, they had the ski accident, and now we're supporting somebody else's family too in these groups, because the money you generate in a practice is based on your time, your services. If somebody's not there, they're not generating money. And so you have to understand that going forward. I mean, maybe things happen and your group says, hey, we'll continue to pay you your normal draw for a month or 2 months, because that's fair. We like each other. We want to help. Bad things happen. We'll pick up the slack. But if it goes on and it goes, I mean, seriously, one practice, I use that example because one practice, a doctor had the ski accident once, but then he kept skiing. And he obviously wasn't a very good skier because he had the same thing happen the next month, the next year. And they were like, come on, we can't keep funding your whole family's lifestyle when you keep choosing to go skiing and break your thumb. Is it production or is it a combination? Again, expense allocation can really jump up and bite people because, again, some doctors in a group, they need to discuss it in advance. I like to practice with 2 mid-levels. Mid-levels are expensive. No, you only need 1 mid-level. And how are those expenses going to be attributed? It's usually easier to say, if you want 2 mid-levels and you're willing to pay for them, we'll allocate that whole expense to you and you can do what you want. We're just not paying for it as other members of the group. Or if you want the fancy Bernhardt sofa in your office or whatever, the desk, and you want to go, that is you. I'm going to go IKEA. That kind of stuff. So just allocate that up front, understand how it's going to be or what truly is a shared expense. Restrictive covenants, I already mentioned, in this type of arrangement where you're buying equity, you're an owner, they can be enforced. Another one, I failed to mention, I talked about non-solicitation. I forgot confidentiality provisions are pretty standard, and they're also considered a restrictive covenant. You're subject to HIPAA. You know that you can't disclose medical information, but in these type of agreements, it also may include business information. So if your practice, your group, your employee, you've come up with some great templates that you've included in your EMR and you want to take them with you to your new employer, that could be a violation of this kind of covenant. Or if you have some new process that is unique to your practice, understand this could come up. Buy-in mistakes, the number one is waiting too late to negotiate, that you've just made the mistake of, hey, I'm going to be an employee for 2 years under a guarantee, and then I get to buy in, and you didn't talk about it up front. And that's usually, that something goes wrong or your expectations not met, something like that. It is a good idea. Like I said, those type of arrangements get very complicated fast. An accountant or an attorney definitely an accountant to understand your tax issues and things like that may be a good idea. Failing to negotiate or review all the documents, not understanding the terms, same issues. Thoroughly investigating the deal, and we've talked about that. Make sure you're getting what you bargained for. We've already mentioned that. Physician-hospital integration. It's getting rare, really rare. I mean, like I said, there are physician groups that are still physician groups that operate as a medical group, but unless you're maybe in a rural area, there is some type of other contractual relationship with somebody because of the payment. The payers will just kill you on your payer negotiations, or frankly, it just becomes overwhelming. A small practice, the overhead to have a person that can actually negotiate with Blue Cross and do your credentialing and do your EMR, it just gets crazy. It's crazy expensive. So now you may have accountable care organization contracts. You may be a group that's part of a physician hospital organization, clinically integrated network, joint ventures, IPAs, all these different type of arrangements. They exist. They're their own separate topic, but understand and have that expectation going in. I mentioned some of the laws. Healthcare is ridiculously regulated these days. It just adds so much burden and cost into the system these days. And it is sad and unfortunate, but this is just some of the list of things that you have to be aware of going in, that you are subject. So please, before any deal, I mean, I don't know how many, and that's why health lawyers in my field, we feel like we're always telling people no, which is unfortunate and kind of a downer, because they think, oh, we can do this deal. We're going to, make a lot of money, and we've been proposed this. And then you'll say, yeah, that's great, but that was promoted to you by a person who is not a licensed professional who wants to make money off of your license. And please understand that there's some crazy business deals out there. And they come and they need you way more than you need them. They have a great business idea, but they can't do any of it without a licensed physician to order that lab test, order that x-ray. And guess what? If things go bad, you know whose license is at risk? Yours. You know whose Medicare number is at risk? Yours. Because they're an owner of a deal, but usually it's your clinic that's actually submitting the claim. Or it's your, John Smith PLLC is the one submitting that claim to Medicare. So when they come back, they don't come back after the business owner that or the, deal promoter. Genetic testing labs, urinary drug screening labs, are hot button issues that get in compliance, compounding pharmacies. What else? I mean, just be careful if you get deals, because there are deals and then there are, so be aware of those. Private equity, just to keep it, this is something that now is happening, but this is just kind of a wise that now those groups that have managed to stay independent or physician owned are like, let's let the bankers in New York or come in and buy our practice. And they are offering crazy money. Crazy. I don't know if you know the term EBITDA, it's earnings before amortization, taxes, and blah, 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 interest. And they will offer a multiple on the value of that practice that's just like, wow. How do you justify that? And I don't know how they justify it. Some of it, but private equity, they'll come in and you're just, the dollar signs just go like this. Most of the deals that if you're in a practice that starts, courting private equity or coming in, obviously, again, this goes back to they're making money from your license, your services. So they don't come in and offer you those dollar signs without also a guarantee that you will practice in that same situation and make them money for a certain period of time. So, and they will change your practice. They try to squeeze as much profit as they can. That's their business. They don't see the patients. They don't talk to them. So they squeeze every bit of expense out and they work, so they expect to make a profit. That is the corporate model that you would be entering. Understand that these deals, the ones I've seen at least, are really good for the older physicians. Again, they're like dollar signs, retirement, world, cruise, but they want the guarantee from the younger physicians to stay for a certain period of time. So you're going to be working for them in that model. So you need to make sure you're getting some value out of it and know that that's the deal. So usually I say this is great for physicians at the end of their career. It doesn't look that great for physicians at the beginning of their career. So understand that going in. Any questions about, sorry, I didn't stop after that. I know I'm running out of time. I'm happy to take questions real quickly, right, Sherry? Any?
Yeah, we actually have.
Yes.
So, thanks for all this. I appreciate it. It's really helpful. I think kind of you mentioned a lot about like trying to motivate this stuff. Like when like the interview process a lot of this happens. Like I'll be honest, I'm like I sometimes have like 4 interviews. At no point, I mean, I've talked about like you said, I have good things to kind of try to hang on to about after all these things, the timelines, all this, but like. You don't ever actually see like at what point should who should you bring up? Should it be the COO of the group, the CMO, like their lawyer? At some point they're one of the other physicians in the practice of interviewing. Who is the person to be like, hey man, where like you talk about every detail, but I've never seen a single detail. Like I'm not gonna roll in and they're far away. I have to fly to these places.
Oh my gosh, yeah.
You know what I'm saying? Like I don't want to fly something here and be like, hey, here's the contract. I'm like, dude, none of what we talked about is even like,
Yeah. Yeah, sorry. I'm probably under a thing. Yeah, it is. And if you're going and flying to those places, and again, I know they're taking you to the steak dinner restaurant and it's a little awkward to say, I would ask as soon, you want the introductory, you've kind of got the feel-good meetings out of the way, but say, as early as you can I see your template? Because like I said, they should have a template. It may not even have your name filled in, but what is your standard? What am I going to be asked to sign? I'd really just like to have time to review it. I may be hiring an attorney. It should not be new to them. So just early in the process as you can, do you mind sharing with me a copy of your template agreement so I can kind of get a flavor for how this, and even if it doesn't include my name, I mean, that this isn't, I'd just like to kind of see your model. Probably, usually it'd be coming, if you're in an institution, the COO or the actual business people will have that more than the doctors. Again, the doctors are doing their thing, medicine, and they're more there for the let's get to know you. Do our personalities mesh and that type of stuff? But the business office person should have that right off the top. Yeah. Yes.
For hiring lawyers and law firms to do contract negotiation, is that typically like a percent, a flat fee, hourly?
It can run the gamut, and I can just tell you lawyers are expensive. I get it. There's times where I said, I couldn't afford to hire me. I wouldn't want, and so, usually I can just say what I do, and I do think it's somewhat unique because I get referrals from, like I said, my dad's a doctor, my brother's a doctor, I've worked at the OSMA, I get it, you're coming out, I will take my hourly rate. That's the benefit of me being at a small firm is I don't have to keep the same rate. And so my normal hourly rate is really high, but I will say for your first contract coming out of residency, I discount it. And it usually takes me an hour and a half to review it. What you usually get, and I'm just speaking to myself, I can't tell you what other people do, but this is what I would ask. If you go, to another attorney, say, this is what would you do this on this basis for me too? A discounted hourly rate, guarantee, because they're not going to negotiate. But here's how the process works, is you get to that point, you get that agreement, you send it to someone to review it. And then we go through, do you understand what this means? Do you understand what this means? I have not actually negotiated myself with the other side in years. What happens is you have developed the relationship. I go through the issues and you go back and say, hey, my lawyer said I should ask for this or this. And it's usually the doctor themselves going back. So really the interaction with the attorney in all but the most rare circumstances is, here's the contract you've been given, here are the issues, here's some points where, hey, it doesn't include relocation expenses, and if you're going to have to move to that place far away, you need to ask for relocation expenses. Okay. And so the doctor goes back with those things. It is an, oh yeah, we didn't put that in there, because they won't put it in there till you ask for it sort of thing. Then they'll put it in there. That's how things usually work. It takes me personally, an experienced healthcare attorney that again, this is one of those, you don't want to pay the brand new attorney that will take 8 hours and send you a bill for $1,000. You want one that, has looked at a lot of them. Here's the issues. I can tell them off the top of my head. I went down through this agreement. Here's what you need to think about, doctor. You take it back to that coordinator you've been working with, and that's usually where it ends. Yes.
Can you give us a dollar range?
So,
Mine was like 500 to 1,000.
yeah, again, I can tell you what I do, and so you can compare it going forward. Because I know, I get people, and like I know the bigger firms, they usually send me because bigger firms represent some of the systems, and so they can't represent physicians because it's a conflict of interest. So a lot of my contract reviews come from doctors that had originally contacted some of the bigger firms, and they say, we can't do it because we represent the hospital. So you should call Corey because she can take and do this. And what I do is my hourly rate is usually, over, and I say, I discount it to $275 an hour, and it takes an hour and a half. And so you get a bill for less than $500. That's what. And I usually put that in the engagement letter. I said this should take, if it is the standard, what I usually do, it takes an hour and a half. I'm going to discount it because you're a resident physician, and I do it for $275 an hour. And so it's usually $275 to $400 at the most, depending on how complicated. Thank you, guys. Good luck.